of Edward Hard when he last served him alcohol on July 28th. Your Honors, the defense contends that just because John Daniels testified that he did not, in his deposition statement, that he did not actually witness visible intoxication on the part of Edward Hard when he served him, does not preclude our case from going to trial. The courts have held in Richter v. Klink Trucking that when summary judgment is based on credibility of witnesses, weight of testimony, or the state of mind of a patron, that it is not appropriate for summary judgment to be granted. In fact, the defense also contends that the evidence shows it is improbable that we will recover at trial. In Richter v. Klink, the court also held that mere improbability of success does not allow a granting of summary judgment against the plaintiff or defendant, as the case may be. In this case, the court does not look at a vacuum. We have factors given from Ashlock v. Norris, which allow the court to determine whether a server of alcohol had actual knowledge of visible intoxication when they served a patron. The four factors are what and how much alcohol was served, the time that it was served in, the condition of the patron before leaving, and the condition of the patron just after leaving. In this case, the bar tab shows that Edward Hard purchased 13 alcoholic beverages over the course of the evening, a roughly 2-hour and 24 to 30-minute period. Before the Whites arrived at the bar, Edward Hard's deposition testimony states that he had at least 5 alcoholic beverages, 5 beers. And when they, around the time of 7:07, in roughly a half-hour period, the bartender, from his own deposition statement, acknowledges that he served Hard at least 5 shots of whiskey, well, the record shows 5 shots of whiskey, and 1 beer at 7:43 p.m., bringing the total up to around 6 alcoholic beverages in the course of roughly half an hour. The fact is that the total of 11 beverages served in such a short amount of time is indicative that he would have exhibited signs of visible intoxication. In Jackson v. Gore...
Why do you say that? What's in the record that demonstrates that... what I hear you saying is that anybody who's had that much to drink will be visibly intoxicated as a matter of science?
Your Honor, this is one factor that courts look to determine whether they were actually showing visible signs of intoxication. In this case, this is a strong factor, but it is not the only factor that the court can look to determine.
You had no toxicologist in this case.
There, as in the Jackson v. Gore case, there was an expert witness that was used to evaluate the blood alcohol content that was taken at the police report and relate that back to the facts of the case.
Now, these factors that you're saying that courts look from, they're from what case?
Ashlock v. Norris.
Does the fact that he had a blood alcohol content of .20 at the time of the accident, does that help you in any way?
Yes, Your Honor. The fact that his blood alcohol content was so high indicates that he was obviously served past the point that he was served more than enough alcohol to make him intoxicated, and in fact make him 2.5 times the legal limit. The chart certainly.
But from this record, how do we know that it affected him in any manner?
Well, Your Honor, in Jackson v. Gore, the court had the opportunity to, having gone to trial, that the case had an expert witness that testified as to the effects of such a high blood alcohol content on the patron in that case. In this case, we do not have an expert witness to testify because we have not gone to trial. This is still in the summary judgment stage of procedure. Given that, it is in all likelihood that we will have an expert witness when this case does go to trial, and it should.
Well, doesn't all of your evidence, though, just point to the fact that the bartender should have known? Do you have any actual evidence that he actually knew?
Yes, Your Honor. Well, allow me to clarify my position in my statement there. Your Honor, we do have evidence to show actual knowledge, not constructive knowledge. In Jackson v. Gore, the court cited cases such as Gary of Construction and Colby McRoberts where constructive knowledge has been stated not to be enough to infer actual knowledge. The court noted this and then concluded that given the fact, and this is applying similar factors to Ashlock v. Norris, that given the amount of time that the person was served in Jackson, a total of 5 hours, the amount of alcohol, approximately 13 beverages, his behavior before leaving and his behavior after leaving, that the actual knowledge of the patron was still an issue that needed to be decided at trial by jury.
Well, Mr. Walsh, is the bartender held to a higher standard than your own client? Didn't your own client testify in her deposition that she didn't know he was drunk?
Your Honor,
she knows him better than the bartender, I presume.
Your Honor, the bartender is in some degree held to a higher standard. He's the agent of the tavern, and the deposition record shows that Patrick Gibbs' lawyer warned him that Edward Hard, if he were to be over-served alcohol past the point of intoxication, that he could be held liable for any injuries that occurred thereon. And the statute, the Dram Shop statute itself, does not make any exception for how well you know a person or whether they're your friend or you know that they can hold their alcohol. It is a strict standard that says when you serve them past the point of visible intoxication, that is enough to take it. That is enough to serve that issue. In this case, while she did not know or did not testify that she thought he was visibly intoxicated, she did say he seemed like he'd had a few drinks. His own deposition statement concurs and states that he had at least 5 beverages before they arrived. Again, given this information, this is one factor that the court can look to in conclusion with the other 3. Yes, Your Honor.
Go ahead.
Mr. Walsh, can't you show actual knowledge by circumstantial evidence?
Yes, Your Honor. Circumstantial evidence
Isn't there a lot of circumstantial evidence in this case?
Yes, Your Honor. There is a great degree and a great amount of circumstantial evidence which could be used to infer actual knowledge. And the fact is, the court does not need to conclusively decide either the issue of proximate cause or actual knowledge. They need only to determine that a jury could reasonably infer from this evidence that there is more than one conclusion. And if that is sufficient, if they do conclude there's more than one possible inference, then this needs to be heard by a jury, not decided in summary judgment.
Let me ask you, Mr. Walsh, a question similar to what I asked Mr. Van Mater. It sounds to me like you think Jackson against Gore is your best authority.
Jackson v. Gore is a very strong authority in support of this case.
Now, Jackson v. Gore is a decision of the Indiana Court of Appeals?
Yes, Your Honor.
You got any Indiana Supreme Court authority on this?
On the issue of actual knowledge?
Yes. On how actual has to be, I guess. Isn't that what we're trying to get at?
Yes. Well, Your Honor, there is one case that I'm aware of that speaks somewhat to the issue, although not in depth to the issue of actual knowledge, and this is Delta Tau v. Delta, or Delta Tau. In that case, the court examined both proximate cause and actual knowledge, and as the defense pointed out in that case, just the fact that the individual who served alcohol displayed mere chattiness was not enough to support actual knowledge, and that this would be going to the issue of constructive knowledge. In this case, we are not using just his change in demeanor to support an inference of actual knowledge.
Let me just go back to Jackson against Gore and ask the same question I asked Mr. Van Meter. You got a Court of Appeals authority. Do you know whether the losing party in that case asked for Indiana Supreme Court review of the case?
To my knowledge, sir, they did not. Well, I'm sorry. I should clarify that statement. To my knowledge, I am not sure whether they appealed the decision or not.
Okay. Now let me ask you this. Do you agree with your opponent's characterization that the Garriott case stands for the proposition that constructive knowledge is not enough?
Yes, Your Honor. Garriott Construction as well as Cole v. McRoberts support that constructive knowledge is not enough to support actual knowledge.
Now I have one other question for you, and don't know whether I really ought to say this or not, but
yes, Your Honor.
I used to be in the Indiana State Legislature. I represented the city of Liberty in the Indiana State Legislature, and I was there when this dram shop legislation was enacted, and I know that it was an out-and-out effort by lobbyists for the liquor industry to try to protect taverns from any liability whatsoever, and that was the legislative purpose here. Now, I guess my question for you is sort of one of judicial ethics. Given that I know what the legislative intent here was, and that the legislature intent here was that people like your client lose all of these lawsuits, should I participate in this case at all, since I know what the legislative intent here is?
Your Honor, the issue of intent is something that can be used to interpret the law, which is what the courts do. They interpret the law that the legislature passes in a way that is consistent with the intent of the legislature, to the best of their ability. In this case, given that you sat, and I'm not sure directly how much you were involved in the process, were you directly involved in the passage of the statute?
Well, let's say, I'm going to try to keep asking the questions here and not answer them, but let's say that I was staff counsel for the Democratic caucus in the House of Representatives, so I was an eyewitness to all this, but I didn't actually vote on it.
Your Honor, in the case which is in federal court here in hand, in the Federal Rules of Civil Procedure, the parties can move to recuse a judge if they believe that he has reason to have bias over the case for some reason or another. The Rules of Procedure obviously outline this more effectively than I can and more completely than I can here. However, if it were believed or determined to be that your involvement in with the statute and with the legislature was in such a fashion that it would bias you, then the possibility would be that we could move for recusal.
Thank you. Sorry to take you off your
Creates a
argument.
problem for him, too, if he has an active trial practice.
Thank you, Your Honor. Moving on, the four factors the court used to determine actual knowledge of visible intoxication so far are in our favor, Your Honor. Now, we move to the issue of what was his condition shortly after leaving the bar. He was served his last drink at 7:43 p.m. 5 minutes later, he paid, and he left the bar. The police now, John Daniels in his deposition testimony states that he did not believe Edward Hard was visibly intoxicated when he last served him that beer at 7:43. 5 minutes later, he leaves. At 7:55, the police report is taken for the accident which happened from the drunk driving, and the police report describes Hard as disheveled, swaying, staggering, unable to speak coherently, having poor hand-eye coordination, unsure, in fact, admitting that he has no memory from being served the last drink.
Well, hadn't he just been in an accident, which might explain some of that?
The police report doesn't actually outline any head trauma, which might account for that. However, the fact that he was in an accident does not necessarily preclude the statement taken for the police report. And going to the issue of the condition shortly after leaving, this would be a factor the courts should consider in this case. The officer testified that Hard stated, when asked how he felt very drunk, and that when he had asked how much he had to drink, the answer was mucho. Obviously, he's not being able to communicate on an effective level here. His
Which
behavior.
means what? Mucho? What does that mean?
Well, mucho is, Your Honor, mucho means a lot, but as to a specific amount, the record would state that more appropriately, in that we know he was served 5 drinks, according to his statement. The bartender served him 5 shots of whiskey plus 1 beer, and that he was seen drinking from a pitcher of beer from a friend's table. That's at least 11 drinks plus whatever he consumed from the pitcher. Given that, compared with the statement of mucho, obviously would go with the more definitive statement. However, Hard's own testimony is that he had had a lot, and that was the issue that the defense would like to point out in that case. Given his condition, shortly after
His bar bill
leaving,
that night was sizable, was it not?
excuse me, sir.
His bar bill
His bar bill, Your
was
Honor,
sizable.
was sizable. There were 13 purchased. However, 13 were not seen to be consumed, so the defense does not argue that point necessarily, only that we know he had at least 11. Your Honor, the bartender's testimony, the first statement was that at 7:43, when he last served him alcohol, he didn't look drunk. The police report taken at 7:55 has John Daniels stating that when Hard left the bar, 7:48, a period of 5 minutes, that he looked very drunk. His statement changed in the period of 5 minutes from not drunk to very drunk. Given the fact that we have the time served in, roughly 2.5 hours, we have the amount of alcohol and how much, we have the condition before leaving and the condition after leaving, the court could reasonably infer, or a jury could reasonably infer from this evidence, that John Daniels did have actual knowledge of visible intoxication.
You
Because of
just
that-
mentioned the 4 factors again.
Yes,
What case does that come from?
Your Honor, that case comes from Ashlock v. Norse.
Do you know that Ashlock was decided based upon a different statute than the one we're considering today?
Ashlock was decided in 1985, which was before the Dram Shop statute was passed. However, Ashlock has been cited in cases since then and is still considered good law. The 4 factors used in that case are still used to determine whether actual...
What are those cases in which it's been cited since then that says that it works under the Ashlock's tests work under the new statute?
Your Honor, specifically the cases which would use the factors from Ashlock, whether or not they specifically cite